Hey, Professor Yerba here. This video will be talking about successful device seizure. So, when you get started in a forensics investigation, to get the first step right, you have to properly, lawfully, and successfully seize the device. So you have to take physical possession of that device. So the device could be something like a computer, it could be a online account, it could be a mobile phone, it could be a flash drive, any sort of electronic evidence that's going to go into your cyber forensics report. So for this particular video, I'm going to focus more on mobile devices, so cell phones. When we're thinking about cyber forensics, we need to keep two amendments in mind above all the others: the Fourth Amendment and the Fifth Amendment. So our Fourth Amendment is our right to not be. Our Fourth Amendment protects us from unreasonable searches and seizures. All right. And the Fifth Amendment is to not incriminate yourself. So let's talk about the Fourth Amendment. So if it's a government agent, that means a law enforcement person, an FBI detective, or an investigator. If it's a government person, they need to have a search warrant. They need to follow the protocol before obtaining your device. There are a few exceptions to search warrants, such as consent, but we'll talk about those in a discussion in class. So there's probably about 8 different well-known exceptions to a search warrant, but for the most part, a law enforcement person cannot simply take your phone and begin searching. Private citizens can search devices with lots of caveats. So if you can't violate someone's expectation of privacy by breaking into their house and stealing their phone. You can't break through a password and look at a phone. But as a private citizen, you are not required to have a search warrant to search through a device where there's no expectation of privacy. So that doesn't mean that gives you carte blanche to go out and just start grabbing everyone's phone that you see and start looking through it and see what you can find and try to report some kind of crime or blackmail someone. All of that would be illegal, and private citizens can be civilly sued as well even if they don't break a law. So the laws and the rules are slightly different. They're more restrictive for federal or for government agents than they are for private citizens. When a government official conducts a search, they have to comply with federal, state, local laws governing the seizure of whatever type of property it is. If the seizure or collection occurs lawfully, but the actual seizure occurs without lawful authorization, any of the data collected cannot be used in court and will negate the seizure of the devices and the evidence on those devices. Once a device is physically seized, there needs to be a chain of custody completed and follow that piece of evidence throughout its lifetime in the system. So the chain of custody clearly details in chronological order every hand that the piece of evidence has been in from seizure to deposition. Typically referenced in a criminal case during introduction of physical evidence, a chain of custody can play a large role in civil cases and should not be dismissed. The chain of custody should be clearly documented in a report or form that defines the appropriate details. So here's an example chain of custody document. So it looks like in this one, the piece of equipment that they've seized is a hard drive, and here's the model number. So it looks like it's a Western Digital, and then here's the serial number here in this next part, and the volume serial numbers here, the date that it was seized, the person and the signature of that person. If we've obtained a hash for the drive, you put it here, and if we can know the physical address where this was seized, we can put that here in this form. And then over here you would put in all the details for every change, every time it went somewhere, every time that device was taken out of this evidence bag or used or transferred. You would say it was released by this person, has this tracking number, it was received by this person, and then you put their name, their title, and then I like this form because it gives you a reason for the change. So why did this evidence need to move? Why didn't it stay with Captain so-and-so, or why didn't it stay in the locked, secured evidence locker in building 3? Why did it need to leave? Did it need to go for some analysis? Did you need to make a duplicate? Why did it need to leave? All right, so as long as there's valid reasons for why a piece of evidence moves, that'll be fine. All right. And when we're thinking about mobile forensics, there's really 2 different chains of custody. So the first chain of custody is that physical mobile device, right? And the second chain of custody is the information on that device. If the device holding the information is not properly seized and a chain of custody is not established at the onset, any information gathered post-collection becomes fruit of a... With mobile forensics, there's really 2 different chains of custody. There's the physical custody. With mobile forensics, there's really 2 different chains of custody. There's one for the physical device, so one for that cell phone that the person has seized, and then there's a second chain of custody for the actual data that's contained in that physical device. So if the chain of custody isn't completed at the beginning, and so when the physical phone is taken, if it's just thrown in somebody's trunk and then it's transferred from this person to this person and then it goes over here, but there's no chain of custody to show where the information has gone through the entire process, then all of the data collected is useless. It's not going to hold up in court. All right? At best, you could have a detective use some of that information to coerce or convince or show a suspect that, hey, we have this information, but it's not going to be able to go to court. A few minutes ago I mentioned that there are times when you can conduct an investigation, a search and analysis without a search warrant. So one of those cases is a consent from the owner of the device. Or another one is if you're trying to find the device's owner if it's lost. But if a person gives you consent to say, okay, I give you consent to search my phone calls, or I give you consent to search my text messages because that's what you think there's an issue with. And so the device is sent off, chain of custody forms followed, goes through a trained mobile forensics investigator, and there's nothing in phone calls or text that you have consent for, but while you're looking, your software happens to also pull up videos and photographs, and you find some evidence that would help your case. When you go to try to present that in a court case, it's not going to hold up because you did not have consent, you did not have a search warrant to search those areas. So the whole process, people have to be very aware of what they're allowed to do and what they're able to do. As far as another exception to government agents seizing phones, the tricky area of corporate owned or company owned devices, historically law has mostly ruled in the favor that this is a company device. You have no expectation of privacy. If there's an acceptable use policy that says you're allowed to do just work stuff on this device, then that device is property of the company and the information on it is property of the company. There has been a large case, it's United States versus Finley, where even though the cell phone was owned by the company that this person Finley worked for, personal data was stored on the device and the person had a reasonable expectation of privacy for the data contained on the device. So the company seized the device, investigated, found information, but they weren't able to use it because in this case it violated his reasonable expectation to privacy. So the way that a corporate investigation goes can really vary, and you would need to have a deeper understanding of case law. So in January of 2014, there was a big change to how law enforcement are able to conduct searches of cell phones. So prior to January of 14, a police officer could detain you or pull you over or affront you in the streets and be able to use the doctrine of a lawful arrest or under officer safety. And because of one of those things, because you were either under arrest or because they felt that their safety was of concern, they were able to take your phone and search through it without a warrant. So there are two big cases that challenged this that ended up going to the Supreme Court. It was Riley versus California and the United States versus Worry. In this first one, this Riley, a guy was arrested. So when he was arrested, they found guns in his car and they found a smartphone. The officer looked through the phone, found out that this person had been involved in some sort of gang violence, a drive-by shooting or something. So they arrested him and searched his cell phone. They found his gang contacts, and then they were able to charge him with additional crimes. In the Worry case, they arrested him for possession of cocaine or something. He had just a little flip phone, and in the flip phone they were able to get his home address that he had stored in there, which there'll be another module in this series about burner phones and why you don't cross your personal life with your criminal life. Anyways, they were able to find his home address, and they went to that home address, conducted a search, and found lots of other drugs and other things to add new charges. Right? So again, in January, the Supreme Court says that you can't do that. You can't search without a warrant. So courts generally agree that most objects found on a person can be searched after an arrest, but cell phones are controversial because the amount of personal and identifying data that it may include. And then later on in this article that I'm using from Politicite, you can see that information contained in cell phones is often highly personal and may not have any connection to the reason for arrest. This would permit police to search the entirety of an arrestee's digital life. Such data may contain communications and information about innocent third parties whose privacy interests are also implicated. So right now, this is the law. Law enforcement need to have a search warrant to be able to search your device. There's ongoing legislation right now, or ongoing cases right now, trying to make their way to the Supreme Court because this is still not extremely clear. So a police officer, they will get a search warrant, but I think right now the big issue of, hey, we have a search warrant and we say we want to search the phone. Well, what does search the phone mean? Again, because of this contain high personal data and connection, you can't just say I want to search this person's life. You have to say I want to search their home in this front bedroom in the dresser where I think they're keeping the AK-47 and the pile of cocaine and the Scarface DVD, right? So right now with lots of search warrants, they're saying I want to search this device and I want to see what's on it. So they're kind of going fishing, and that's not how that is intended to work. So that is the end of this on seizure and Fourth Amendment. Thanks.